The following presentation is going to cover various topics of the court systems in the United States. This will be presented by Destiny Flowers, Mackenzie Carson, Alyssa Lambert-Alonso, Dominique Scott, Shaeleigh Welker, and Max Henney. The following topics will be discussed and covered throughout this presentation.
Okay. The Judiciary Act was one of the first acts of our first Congress. George Washington was the president and signed it on September 24th, 1789. Originally, the act was there for Congress to regulate jurisdictions for all federal courts. The Supreme Court would handle all the appeals from federal and circuit courts, while those courts would have limited jurisdiction. In 1891, Congress separated the tier of appellate circuit courts, which would not force Supreme Court justices to travel to hear the cases. There is one Chief of Justice of the United States and 8 associate justices on the Supreme Court today. And Congress made 13 Court of Appeals and 94 district courts. The American Law Institute's Model Penal Code was first assembled in 1962. It is based on general liability, defines particular offenses, governing treatment in corrections, and governing correctional departments. It standardizes mens reas to determine the defendant's mental state. Edward Livingston was the first to comply the American Criminal Codes in 1826. It had potential, but had the least successful efforts. It was divided into 4 codes: Code of Crime and Punishments, Code of Procedure, Code of Evidence, and lastly, Code of Reform and Prison Discipline. David Field was a New York lawyer who revised Livingston's American Criminal Code. Although it was less ambitious, it had greater success. The Supreme Court was first assembled in New York City in 1790 with Chief Justice John Jay as the lead. The first court they did was West versus Barnes, delivering the first opinion on August 3rd, 1791. The Supreme Court is the court of last resort. It is the head of the federal court systems and has the ultimate last word. To be on the Supreme Court, a judge must be appointed by the president and confirmed by the Senate. In the Supreme Court, there are always one Chief of Justice and 8 associate justices, unless a seat is waiting to be filled in. The current Chief of Justice is John Roberts. Writ of certiorari requires that if the Supreme Court wants to hear a case, 4 out of 9 judges must vote for the order. The order requests the lower courts to send the case records to the Supreme Court to review. The Supreme Court corrects legal errors and is the last resort of for those errors to be corrected. To have the Supreme Court even look at the case, someone must file within 90 days of the final judgment. Drug courts were placed to influence offenders to stop abusing alcohol and drugs and to encourage them not to relapse. Drug courts screen and assess so they can help with needs and try to reduce the risk. There are 4 phases that require monitoring and supervising to help keep those offenders from relapsing. Sometimes they need breathalyzers. Sometimes they give breathalyzers for the offender's car to so that they can use it before they drive, every time before they drive. Or they'll give ankle monitors to watch and make sure that alcohol is not going in the blood, like nobody's drinking alcohol. In the first 30 days, The offender must be sober with no court sanctions and weekly hearings 3 times a week. The second stage, the offender will do random drug tests, and they're required to complete a two 12-step meetings. This is also the stage where you'll start your repayments, and they must be 60 days sober with no jail sanctions. The third stage, you must go to court every 3 weeks and find a sponsor. The final stage, the offender must go to court once a month. They must complete their repayments and community projects. And at this point, the offender would be 6 months sober. Programs like AA meetings and support groups also increase the chances of the person staying sober. Any powers that aren't granted to the federal government by the U.S. Constitution are given to the state. The state may address issues within their state and place laws for those issues in favor of the public. For an example, abortion laws. It is up to the state to make abortion legal or illegal. Judges are fair, independent, and qualified to protect the most oppressed in our society. Judges hold their office as long as they have good behavior. Judges can be impeached by Congress if they have bad behavior or behavior frowned upon by society. Judges, while they're in office, cannot have their salaries reduced. Circuit judges or appellate judges are judges for Court of Appeals. Typically, they sit 3 judges to a panel. Sorry. District court judges handle both criminal and civil court cases and are responsible for supervising pretrial and trial proceedings. Senior judges are judges who reach service and age requirements, which for a judge to be a senior judge, they would have to be 65 years old and serve at least 15 years on the bench, or any combination of the age and the years, at least that equal out to be 80. But they must serve at least 10 years before they can have a senior status. Last but not least, there are magistrate judges. They issue warrants, conduct preliminary hearings in criminal cases, and hear petty offense cases.
Okay, so for my first one, I talked about jurisdictions. They're the official power to make legal decisions and judgments. The territory within a court or government agency where they can properly exercise their power. They have 3 components. They have personal jurisdictions over the subject matter jurisdictions and jurisdictions to render the particular judgment sought. Federal courts have limited jurisdictions, and any court has jurisdiction over matters only to the extent granted to it by the Constitution or by legislation of the sovereignty on behalf of what it functions. The next one, as I did, original and appellate courts. Original is Supreme Court is the first and only court to hear a case. Appellate, the court has authority to review decisions of lower courts. There are 13 appellate courts total that sit below the Supreme Court, and they are called the U.S. Court of Appeals. There are 94 judicial districts split into 12 regional circuits. Each has a court of appeals. And the main goal of an appellate court is to determine whether or not the law has been applied correctly during the trial court. And there are 3 judges, no jury. My next one was public access to criminal proceedings. Federal courts recognize that the right to public access to criminal proceedings is embedded in the First Amendment, the 6th Amendment, and in common law. The First Amendment goes beyond protection of the press and prohibits the government from limiting the information in which the public may access. Sixth Amendment states that the accused have the right to a speedy and public trial. The Supreme Court stated that criminal proceedings should be open to the public unless there is an overriding interest favoring a closed trial, which will be voted on. and allowing public access to criminal proceedings denies any potential for like abuse of judicial power or any of that. My next one was situs of the court. Situs means the location of property or any items for legal purposes. Where the situs of something is depends on what the item is and has a chance of having important legal consequences. They include physical items, intangible items, and the physical items are the situs is the place where the object is located. So example would be like a house or a car. The intangible items would be where the property or the item is registered. So like a patent or something like that. My next one was right to counsel, Gideon versus Wainwright. There was embedded in the Fifth and Sixth Amendment. Fifth Amendment is the right to counsel protects any pretrial interrogation, and the Sixth Amendment is the right to counsel provides a criminal accused the right to a lawyer in his or her defense, even if they cannot afford one. So one should be appointed for them. Sixth Amendment guarantees the rights of criminal defendants, including the right to a speedy and public trial, the right to a lawyer, the right to an impartial jury, and the right to know your accusers and the nature of the charges and evidence against you. These were not applied until 1963 in Gideon versus Wainwright. Gideon was not appointed a lawyer when charged for breaking and entering, so he represented himself. He was found guilty and sentenced to 5 years in prison. While he was in prison, he filed a habeas corpus petition for the Supreme Court saying his constitutional rights were violated. A unanimous opinion was given that the state courts are required to appoint attorneys for the defendants, and the right to counsel was also ruled by the Supreme Court that it should be the right to an effective lawyer, not just any lawyer. The writ of habeas corpus is a fundamental right in the Constitution that protects against unlawful and indefinite imprisonment and is used post-conviction for state and federal prisoners. They challenge the legality of their convictions, if it was valid or lawful. When you file a habeas corpus, it isn't to like defend your guilt or your innocence. It doesn't depend either of those or determine it. It is a civil action against the state who hold the defendant in custody. It is used to determine preliminary matters in criminal cases. So either the removal to another federal court, denial of bail or parole, claim of double jeopardy, or the failure to provide a speedy trial. You're right. U.S. Constitution and establishment of the courts. It was written in 1787, ratified in 1788, and has been in operation in the United States since 1789. It was written to affirm that the government exists to serve the citizens of the United States. Article 1 creates a Congress, which would be the Senate and the House of Representatives. It gave Congress the responsibility of organizing executive and judicial branch, raising revenue, declaring war, and making all laws necessary. The first Congress created the Judiciary Act of 1789, established the federal court system separate from the individual states. It stated that Congress would regulate jurisdiction of all federal courts, and the federal district courts and circuit courts would have specific but limited jurisdiction. The Supreme Court would have original jurisdiction. It was signed into law in 1789. And the act made up the district courts, the circuit courts, and the Supreme Court. Article 3 of the Constitution created the Supreme Court, which then led to the establishment of lower courts. And that is all.
So the first topic I'm going to discuss are pretrial issues. So after a suspect is arrested, a prosecutor reviews the facts and evidence of the case to determine if they should be criminally charged. If there are no charges, the suspect is immediately released. So if charges are pressed against a defendant, the suspect is brought before a lower court judge for an initial appearance. At the initial appearance, the defendant is advised of the charges pending against them and advised of their constitutional rights. If the defendant is unable to afford an attorney, this is also the point where one is appointed for them. So for different crimes, there are different steps into this. So for misdemeanors or ordinance violation cases, a summary trial, which is an immediate trial without a jury, may be held. Or in felony cases, a preliminary hearing is held to determine whether the defendant should be released or whether there is probable cause to have a preliminary hearing. So the next step in this part is the pretrial motions. So before a trial, the prosecutor must file a motion and the judge determines the outcome. A motion is an application to the court made by the prosecutor or defense attorney requesting that the court make a decision on a certain issue before the trial begins. The motion can affect the trial, courtroom, defendant's evidence, or testimony. So the following list I have here are the types of motions. The first one is motion to dismiss. This is an attempt to get the judge to dismiss a charge or the case. This may be done if there is not enough evidence or if the alleged facts do not amount to a crime. The next one is motion to suppress. This is an attempt to keep certain statements or evidence from being introduced as evidence in court. So, for example, if police conducted a search without probable cause, which is a violation of the Fourth Amendment, it may be possible to suppress the evidence found as a result of that unlawful search. And the last one is the motion to charge. This may be made for various reasons, including pretrial publicity. If the local news has covered the case a great deal, it may be necessary to move the trial to another venue to protect the defendant's right to an impartial jury. The next topic I'm going to discuss is adjudication. So it comes from a Latin origin of judicare, which means to judge. And it refers to the legal process of resolving a dispute in civil cases or deciding a case in criminal cases. It also refers to the judicial decision itself, which is the final judgment in a legal proceeding. Most adjudication hearings occur over monetary disputes in civil cases or nonviolent infractions in criminal cases. So the first type of adjudication is juvenile adjudication. It is defined as the court process that determines if a juvenile committed a criminal act. It is also the equivalent of guilty for juveniles. And then the next type of adjudication is agency adjudication, and there are two types of this. The first one is formal. It is a trial-like hearing with witness testimony, a written record, and a final decision. And then the second type is informal, statutorily required decision-making process that may or may not require a hearing and is neither formal adjudication nor rulemaking. And instead of having like your typical hearing, it is done through inspections, conferences, and negotiations, and it must be permitted by the Administrative Procedure Act. The next topic is appeal. It is defined as a challenge to a previous legal determination. It is directed towards a legal power higher than the power making the challenge determination. So in 1789, James Madison argued for the adoption of the Bill of Rights, which included habeas corpus. Trial court determinations can be appealed in the appellate courts, and the rulings of the appellate court can be reviewed by the U.S. Supreme Court. So this gives the opportunity for defendants to try to raise specific errors that may have occurred during their trial. Criminal defendants who were convicted also have an absolute right to appeal their convictions. So there are two types, or two main categories of appeals, I should say. The first one is appeal by right, and this involves cases that the appellate court must hear. And then the second type, which is appeal by permission, this is discretionary, and it involves reviews of lower level decisions that the court may or may not choose to accept. So the types of appeals that defendants can bring upon to the appellate courts are listed here. The first one is the right to appeal, which is a constitutional right, and it usually is like it's brought up whenever there's an error in the trial or there's poor legal representation. The second one is the writ of certiorari, which is Latin for to be more fully informed. So this is when a higher court ordered a lower court to send up a case record for review, which is often as a result of a petition it's like a prisoner petition, which leads into the second one, which is the writ of habeas corpus. This is Latin for show me the body, and it's used to determine if a state's detention of a prisoner is valid. It's used to bring a prisoner or other detainee before the court to determine if the person's imprisonment or detention is lawful. A habeas petition precedes a civil action against the warden that holds the defendant in custody. So the next topic is arraignment. It comes from the French word oresnier, which means to address or speak reasonably. This is where the formal reading of the charges occur, and this is also the stage where the defendant enters a plea. So there are three types of pleas that a defendant can enter. The first one is a guilty plea. So if a defendant pleads guilty, they must admit in an open court upon a judge. At this point, no trial occurs, but the defendant must attend a sentencing hearing where the judge determines their punishment. The second type of plea is a not guilty plea. If a defendant pleads not guilty, the case is taken to trial and the plea bargain is withdrawn, which I'll get into that next. And then the third type of plea is the plea of nolo contendere, which is also known as a no contest plea. This must be allowed by the court. In this point, the defendant is not admitting guilt, but accepts responsibility for the criminal act. So they are not required to address their own crimes and no trial is held. And the next step is they go to their sentencing hearing. So the plea bargaining is a reduction in charges and punishment in exchange for a guilty plea. So it's most of the time it's a guilty or not guilty plea that's involved, and it provides a way to resolve cases in a more efficient manner. So when there is strong evidence against the defendant, they may be offered a plea deal to avoid trial and potentially reduce the risk of a longer sentence. And then the next topic, I'm going to go a little bit in the history of the bail system before I get into actually explaining what it is. So in 1789, the Judiciary Act of 1789 was the very first bail law set in America. It established that bail must be set for all crimes that were not punishable by death. So before this bill had been practiced, before this law was officially passed, however, there was no legal stance and it was not official by the government. So this leads up to 1791, which is when the Eighth Amendment was passed. It was written by James Madison in the Bill of Rights, and it states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Then in 1966, the Bail Reform Act was created. This created the presumption of release, meaning people accused of crimes would be released freely instead of being held until they posted bail. So bail was first established with the idea that if people had to pay the court, they would be less likely to flee. And the criminal would leave freely under the assumption that they would choose to return on their own without incentive. If there is proper evidence that the defendant would flee, the release could be rebutted. And then going to 1984, that's when the Bail Reform Act was created. It was also called the Comprehensive Crime Control Act of 1984. So while it was possible that a defendant could be released without posting bail, this law allowed the courts to take into consideration whether the alleged criminal is a threat to the community. So in this instance, the judge decides bail, and bail was given to defendants as incentive to attend trial and protect the public at large if they were a menace to society. So I'm going to now explain the actual hearing for bail. So this takes place after the initial appearance and before the arraignment. The court determines if the defendant is eligible for bail, and if released on bail, the defendant has made a financial promise with the court to appear at trial. So just to define the terms a little bit, bail is a promise to return for future court appearances in exchange for one's release during the pretrial stage. And then bond is posted on defendant's behalf, usually by a bail bond company, to secure their release. So going back to the second point up here, courts set the cash amount, which is the bail, that the person must pay to ensure their appearance at trial. And if the person appears, the court returns the money, and if not, the court keeps the money. So that's the incentive. And so the second thing is that they usually have a bail bonds person. Some defendants do. So the defendants will use a bail bonds person to secure their bond. So how this works is the defendants pay the person a fee along with some form of collateral, which could include a deed to a home or a car, in exchange for the bonds person to put up the remaining amount of their bail. If the defendant fails to appear, the bonds person seizes the asset to pay the debt owed to them. So one problem that does come from this entire system is that some defendants are unable to pay, so they are incarcerated during the trial proceedings, even though they have not been convicted of a crime. So this kind of favors those who come from money or are able to get money easily. Right, and then the next topic I'm going to discuss is celerity. This comes from the Latin root celere, which means fast, quick, rapid, or swift. It is defined as the notion that potential punishment must occur in a timely fashion. This also derives from the deterrence theory. So Cesar Beccaria's plain pleasure principle is kind of applied to this concept. So this was used to explain that individuals choose their behaviors based on the amount of pleasure versus pain derived. He was the first person to study penology, which is a subfield of criminology that specifically looks at issues of punishment, incarceration, and rehabilitation. So the deterrence theory was linked to this principle. And just to define deterrence, it's defined as the suggestion that people will avoid potentially pleasurable acts if the pain or fear of punishment is significant. So the most effective punishment that deters people from committing crimes must be certain, severe, and swift, which is where celerity comes in, and I'll define those terms right after I explain the types of deterrence. So there are two types of deterrence, like I stated. The first one is special deterrence, which is how an individual may avoid criminal behavior if the potential punishment is viewed as undesirable. And then there's general deterrence, which suggests that people fear the punishment that others receive. If people fear the punishments that others receive, they will decide not to engage in similar acts to avoid this punishment. So this theory overall suggests that offenders will be discouraged from committing crimes if they fear the punishments associated with these acts. So going back to the explanation for an effective punishment, celerity is one of the three characteristics that is needed for it to be effective under this theory. And so the first one is certainty, which is the notion that individuals need to be reasonably aware if they engage in a criminal act, they will be apprehended and punished. The next one is severity, which is the notion that punishment must be harsh enough to deter people from criminal behavior. And then celerity of the punishment refers to the amount of time between the criminal act and the punishment for said act. If the punishment does not occur in a timely fashion, the deterrent effect is reduced. If defendants know how swift the punishment will be, they will not offend. And the next topic is charging. So in criminal cases, a charge is a formal accusation of criminal activity. The prosecuting attorney decides on the charges after reviewing police reports, witness statements, and any other evidence of wrongdoing. In jury trials, a charge is the instruction given by a judge or jury regarding the law, its application, and the weighing of evidence. The charge must tell the time, date, and place that the criminal act allegedly took place, the alleged involvement of the accused, and the details of the crime itself. So there are three ways to bring a charge. The first one is an indictment. This is voted by a grand jury, and the prosecutor decides when the case goes to a grand jury. So the grand jury decides if there is enough evidence to charge the accused with the crime. This is meant for there to be an unbiased opinion and that it's solely based on evidence. The next one is filing of information or a criminal complaint. So the prosecuting attorney files information alleging that a crime was committed. Charges can be pressed through filing a criminal complaint by another individual, which is a petition to the attorney asking them to initiate criminal charges on someone. And then the last way is through citations. This is given by police officers for minor traffic violations, and it's also used for petty misdemeanors and other minor criminal matters. So the next topic is custody. Custody is the state of physically holding or controlling a person or piece of property or of having a right to do so. It is synonymous with restraint of liberty and does not necessarily mean actual physical imprisonment. So custody under criminal law, a person is in custody when after being arrested or convicted of a crime. This means they are held in jail or prison. Such persons are under state control until they are acquitted for their alleged crimes or the conclusion of their prison sentence. People that are in custody are limited in their liberties and dependent upon officers to meet their needs. And once they are arrested, property is taken into custody during the booking process. All personal effects are held in police custody until the person is released, and any contraband or anything illegal that they had on them does remain in police custody for the time. And then custody and family law. So the question of custody generally arises after the separation or divorce of a minor child's parents. So there are 4 types of custody. The first one is physical custody. This is where the court determines who lives with and cares for the child. The joint physical custody, this is where arrangements allow for a child to spend equal time with both parents. And then there's primary or sole custody, which is where the child spends a majority of the time living with one parent, which is their custodial parent, with non-custodial parents having visitation rights. And then the last one is legal custody. This is the right to make important decisions regarding the child's health, welfare, and upbringing. Okay. The next topic is equity. This is defined as the state, quality, or ideal of being just, impartial, and fair. This refers to fairness and justice in simple terms. So through equity, it means we are recognizing that we do not all start from the same place and must acknowledge and adjust to these imbalances. So the first type of equity that I came across was systemic equity. It is a complex combination of interrelated elements consciously designed to create, support, and sustain social justice. It is a dynamic process that reinforces and replicates equitable ideas, power, resources, strategies, conditions, habits, and outcomes. So, for example, communities with a sizable portion of incarcerated residents are economically burdened and consequently lack resources to properly support their families. So systemic equity can be applied in this situation to support children and families of those that are incarcerated. And then the next type of equity is racial inequity. So this is a process of eliminating racial disparities and improving outcomes for everyone. It is the intentional and continual practice of changing policies, practices, systems, and structures by prioritizing measurable change in the lives of people of color. It also seeks measurable milestones and outcomes that can be achieved on the road to racial justice. So there are another subcategory under this is racial inequity, and there are 3 types. So the first one is structural racial inequity. This is the interplay of policies, practices, and programs of differing institutions, which leads to adverse outcomes and conditions for communities of color compared to white communities that occurs within the context of racialized historical and cultural conditions. So an example would refer to wider political and social disadvantage within a society. And then the second type of inequity is institutional racial inequity. So policies, practices, and procedures that work to benefit the white population and the detriment of people of color, usually unintentionally and inadvertently. It does occur in institutions of education, criminal justice, and health. So, for example, the stop and frisk policies, some of these may target people of color and the generalization of some of criminal justice professionals. And then the last type of inequity is individual or interpersonal inequity. This is the prejudgment, bias, and stereotype or generalization about an individual or group based on race or Yeah, based on race and how a person perceives others around them in an unfair and unjust way. And I just thought it was very important to discuss the difference between equity and equality because I feel like that is a very common misconception between these two. So just to define them real quick, equity, it uses differentiated and targeted strategies to address different needs and to get fair outcomes. And equality uses the same strategies for everyone, but not all outcomes are the same since people have different needs. So equity does ensure that outcomes of each individual of each individual's well-being is improved, and it focuses on improving marginalized groups and lifting the outcomes for all. And equality kind of ignores the reality of marginalized groups. So in this example, this photo example, all of these kids are the same height if they were to stand on flat ground. But for example, this kid has 3 steps here and they are on a lower ground. This person has 2 steps, they're on a mid ground, and this person has 1 step, but they are on the highest ground. Plus there's also a slant here. So this person has most of the disadvantages out of the 3. So he needs more support in order for him to see the game in this picture. So equity kind of focuses on, again, each individual need here, whereas equality, if you give them the same type of treatment or same type of help, this person here still is not able to, see the game. Same with this one. This kid has to go on their tippy toes while this kid is able to see. So this is just kind of like a visual representation of differentiating equity and equality.
Initial contact is the first step in a criminal case. In this step, law enforcement acts against a suspected perpetrator. Police officers contact said suspect and inform them about their violations that they've committed. An investigation begins, apprehension of the offender is made, and booking them into the local jail happens once an officer has made the initial contact. After this initial contact, an initial hearing or arraignment takes place. Lex apparens is apparent law. Lex is the sense of the process of law. This is the law which is apparent of made manifest in a trial or battle or trial by ordeal. The plaintiff was obliged to make his right clear by the testimony of any witness. This is before they can obtain an order from the court in order to summon any defendant. A preclusion is a valid and final judgment that binds a plaintiff or a defendant in actions on different causes of action between them. There's 4 elements that decides whether the issue preclusion applies. A former judgment must be valid and final. The same issue is being brought. The issue is essential to the judgment, and the issue was litigated. A preliminary hearing is an option for the court to determine whether or not probable cause exists for a case to move forward. The defendant may waive the right to a preliminary hearing. It must be held within 14 days of the initial appearance if the defendant is being held in custody. If the defendant is out on bail, it must be held within 21 days of the initial appearance. If they are in custody, he or she may have a bail hearing afterwards to determine whether they are eligible for bail. This is considered to be a mini trial, and if the judge concludes that there is probable cause, a trial will soon be scheduled. Also, at a preliminary trial hearing, there will be evidence presented that establishes prima facie. Prosecutorial discretion is the power of the government to decide a certain course of action when contemplating the circumstances of any event that results in a criminal prosecution. It's an authority in play the second a prosecuting attorney is made to make a final sentencing. This gives them the ability of proving guilt beyond a reasonable doubt. When there is not enough evidence, any case can be withdrawn or other charges can be brought up. A positive to prosecutorial discretion is it helps promote judicial economy. Because there is so much on a court schedule, being able to charge a defendant or enter a plea bargain eases a burden on themselves, judges, and the courts. It gives the authority to enter plea bargains with a defendant, entering a guilty plea for a lesser charge or sentence for pleading guilty or any original charge. A negative to this Prosecutorial discretion is it can create misconduct for prosecution. When their beliefs and biases are in the way, it can find its way into their decisions. Severity of sanctions. Criminal sanctioning involves judges or juries punishing individuals for committing crimes. The 5 types of sanctions are incapacitation, deterrence, retribution, rehabilitation, and restoration. Sanctions are penalties imposed on individuals who commit crimes. The 4 most common sanctions are imprisonment, probation, fines, and community service. Imprisonment and probation can range from months to years. Fines can range from hundreds to thousands of dollars. Community service hours vary depending on the crime committed. There can also be house arrest, capital punishment, and restitution criminal sanctions. There are many steps to a criminal trial. While some are simple, some others have more steps. The investigation is used to obtain evidence and assist the prosecutors understand certain details of a case. Charging, after gaining all the information from investigators, they decide whether or not to present a case to a grand jury. An initial hearing or arraignment, the same day or date after the defendant is arrested and charged, they are brought in for an initial hearing. They're told their rights, charges, and attorney arrangements. A judge also decides if said defendant will be held or released until the trial. A discovery, a prosecutor must become familiar with the facts of a crime, talk to witnesses, and study any and all evidence and develop a strategy. Plea bargaining is when there may or may not be an offer to a defendant for a plea deal to avoid a trial and reduce their sentence. If a defendant pleads guilty, there is not a trial, but there will be a sentencing hearing. Preliminary hearing is a mini trial that must be held within 14 days of an initial appearance if the defendant is being held in jail, and 21 days if the defendant is out on bail. The judge concludes whether there is probable cause is there. If not, the judge will dismiss the charges. Pretrial motions are motions to dismiss, motion to suppress, and motion for change of venue for some pretrial motions. Trial is a structured process that is presented to a jury. Prosecutors use witnesses and evidence to prove to a jury that said defendant has committed the accused crimes. The defendant's attorney gets a chance to tell their side of the story, also using witnesses and evidence. Post-trial motions. There are motions for a new trial, motion for judgment of acquittal, and motion to vacate, set aside, or correct a sentence are some post-trial motions. Sentencing. So after a defendant is found guilty, they come back to court in order to be sentenced. The judge uses many sources and takes a lot into consideration before sentencing. An appeal is after a defendant is found guilty, they're still allowed to appeal if they believe that they were wrongly convicted.
A plea bargain is a negotiation between a prosecutor and a defendant. It only happens in criminal cases, and there are benefits for defendants and the prosecutor. Some benefits for defendants include less anxiety, lesser charges, a reduced sentence, or they may avoid incarceration completely. Benefits for prosecutors may include a quicker trial and also reducing the workload of the courts. And then there are disadvantages in plea bargaining for defendants because many times defendants are coerced into taking a plea bargain, even if they are innocent. This happens a lot. There are also no jurors involved, and the judge's role in the plea bargain is limited, and they're not bound to the prosecutor's suggestion. Courtroom culture is the custom, norms, and practices within the legal system, such as standing for the judge and referring to them as your honor, and the actors are held to a high standard of professionalism. Judges are often elected or appointed, and they preside over the courtroom proceedings. They are an impartial evaluator of every case. The prosecutor presents evidence to support charges against the defendant, and then the defense attorney represents the defendant and attempts to cast doubt on the prosecutor's case. The defendant is a person or entity that has been accused of a crime, and they may either be a criminal or a civil defendant. Witnesses are people who testify under oath regarding an experience involved in a certain case. And then they can be cross-examined by the defendant's attorney also. They have testimony in support of the prosecution case against the accused. There are also people called expert witnesses, which are professionals in a certain category, and then they can provide their expertise on that specific category. And then also, if witnesses are threatened for any reason, they can be put under witness protection. Amicus curiae means friend of the court in Latin, and it's used to refer to a legal brief, a person or an organization that is not in a party within a legal case, but volunteers an opinion or information to the court. If you've ever heard of the Innocence Project, they are a party that will put themselves in a case. And also, if the court accepts the brief, they may be filed with an appellate court or the state Supreme Court. There are often public interest in civil rights cases. A challenge for cause is the dismissal of a juror, possible juror, because it's believed that the individual could not be fair or unbiased. This is a legal procedure that allows, it's a legal procedure that a pool of potential jurors are called to the courthouse, and then they're asked questions by the attorneys and the judge. And a party can request a potential juror to be removed for a specific reason. Normally, if there's a personal connection to a party, a conflict of interest, prior knowledge or opinions on the case, or disability that prevents them from fulfilling the juror job. Jurors are individuals chosen to serve on a jury and determine the verdict of the case. There are 12 jurors, and there can be no outside influences. They must listen to both sides, and then they come to a unanimous or a majority verdict. There are certain requirements, such as they have to be over 18 and a U.S. citizen, no felony convictions, no disqualifying physical or mental condition, and they must be a resident of the judicial district for a minimum of a year. They must also speak, read, and understand English. Jury hearings happen after the arraignment. State needs enough evidence to establish probable cause. And in these cases, they have a grand jury, which means that there is no judge present. And so there are normally 16 to 24 jurors, which is different than the normal juries, which is 12. And then the state issues an indictment against the defendant and then stands trial for the charges. Peremptory challenge is a command, ruling, or decision that does not allow for questioning or debate. They have special jury challenges where a lawyer can exclude a potential juror from a trial with no real reason or explanation. But there are limits on how many times it can be used, and it is different from some criminal and civil cases. The peremptory challenge cannot be used to exclude based on race, gender, or religion, or other protected characteristics. Prosecutorial misconduct is the act of breaking the law or code of ethics while working as a prosecutor. These people are responsible for determining who should be held accountable for a crime that is committed. There are different types of prosecutorial misconduct, one being Brady violations, which is when the prosecutor withholds evidence that may be favorable to the defense, and they have to turn over all evidence, whether it proves the defendant guilty or not. Unethical evidence is another problem, which is just introducing evidence that was collected unethically. If this is used, the case could be turned over, and the same goes for presenting false or misleading evidence. And they cannot discriminate against the defendant based on age, race, religion, and things such as that. Unethical relationships in court cases include romantic relationships between lawyers and clients and witnesses, or any of the three. Business or social relationships between judges, lawyers, or court personnel can appear as favoritism. Their relationships must stay professional inside of the courtroom. And there may also be coercion if there's a relationship between a prosecutor and a defendant. The prosecutor may pressure the defendant to take a plea deal by threatening harsher punishments. And also, if there is inappropriate communication between judges and lawyers that is found out, it could affect the ruling of the case. Voir dire is the purpose of this is to ensure that the jury is impartial, unbiased, and capable of rendering a fair verdict. There is a series of questions asked by the judge and attorneys to establish qualifications and suitability to serve on the jury. It is to determine whether there are any biases towards the case or the defendant. It can also be used to identify if jurors are sympathetic or unsympathetic and make sure that they have no prejudices that would affect the case. In a federal case, though, there are certain people that are just disqualified, such as professional law enforcement officer, a professional firefighter or EMS provider, a public officer working in federal, state, or local government, and a member of the armed forces or active duty. They are not allowed to participate in juries of a federal case.
Hello, my name is Max Henney, and the first topic I will be discussing is the judicial decision-making process. This involves nol pros, stare decisis, and writ of certiorari. Nol pros. This is a legal notice or entry of record that prosecutor or plaintiff has decided to abandon the prosecution or lawsuit. This term is used by the prosecution to declare the voluntary ending of a criminal case after the filing of formal charges, but before the case could be dismissed by the court or verdict could be rendered into trial. Reasons for a nol pros include successful pretrial diversion program, realizing that insufficient evidence supports the charges, finding out a witness is unavailable or waivers, or learning that the witness has filed a request to not prosecute. Stare decisis. This is when a court will look at previous judgments while resolving a case with allegedly comparable facts. The previous deciding court must have binding authority over the court. This doctrine applies both horizontally and vertically. The horizontal aspect refers to when a court will follow its own prior decisions. The vertical aspect refers to a binding of a lower court to follow strictly the decisions of higher courts within the same jurisdiction. Since the U.S. Supreme Court is the nation's highest court, all states rely on the Supreme Court's precedents. Writ of certiorari. This is when a party is not satisfied with the decision of a lower court and they can petition to the U.S. Supreme Court or the state Supreme Court to hear their case. If the writ of certiorari is granted at the Supreme Court's discretion and only when the Supreme Court members believe that the case involves a sufficiently significant federal question in the public interest. If the writ is denied, then the Supreme Court says it will let the lower court decision stand. Granting a petition for certiorari requires affirmative votes of at least 4 out of 9 Supreme Court justices. If the writ is granted, the Supreme Court will hear the case. The Supreme Court prefers to listen to cases in which its ruling will provide definitive guidance to lower courts. Possible reasons to grant petitions for certiorari include cases that resolve clear conflicts of law, cases in which a lower court disregards the Supreme Court, cases that are important or unique, or cases that are interesting. The second area I will be discussing is the juvenile justice. This involves en regalt, juvenile proceedings, Roper v. Simmons, and steps in the juvenile justice process. En regalt. This is a case where juveniles were granted to be given due process. It is a case where 15-year-old Gerald Galt was arrested and neither of his parents were notified by the police. The issue in this case was they needed to determine the procedural rights of a juvenile defendant in delinquency proceedings where there is a possibility of incarceration. The court held that due process required that the child and their parents or guardian must be notified in writing of the specific charge or factual allegations to be considered at a juvenile delinquency hearing. Such notice should be given at the earliest practicable time and in any event sufficiently in advance of hearing to permit preparation. It was further held that juveniles shall be granted the assistance of counsel, as no person should be compelled to be a witness against themselves when they are threatened with the deprivation of liberty, and it is essential for determination of juvenile delinquency. Juvenile proceedings. Community safety is a goal of both the juvenile and adult justice system, but the juvenile system is more oriented toward rehabilitation process for the kids. Judges typically decide juvenile cases, as only a few states provide juvenile jury trials on rare occasions. The first process is the jurisdictional stage, which is where a judge must decide whether there are grounds for intervention. The second stage is the dispositional phase, which is where a judge will decide how to intervene. Juvenile proceedings. The philosophy of the early juvenile court emphasized 4 tenets: rehabilitation, to try and save the wayward child through appropriate treatment; individualization, to be able to determine if a child needed help and then to try to meet their individualized needs and treatment; separation, to keep children away from adult criminals who can endanger the safety of the child; and formality, the purpose of the juvenile proceedings will be rehabilitation. Henry Galt has an important role in juvenile proceedings, as it is the reason that these juveniles are given due process. In the years preceding the Galt case, several cases expanded the constitutional rights of children in juvenile hearings. Roper v. Simmons. This is a case where juvenile offenders under 18 cannot be sentenced to the death penalty. Simmons was 17 and planned and committed capital murder. The issue in this case was, does the 8th Amendment forbid the imposition of the death penalty on juvenile offenders under 18? The answer was yes. The court held that juveniles are less culpable than the average criminal and provided 3 reasons. The first was the lack of maturity and an underdeveloped sense of responsibility were found in the youth more often than in adults and were more understandable among the young. Second was juveniles were more vulnerable or susceptible to negative influences and outside pressures, including peer pressure. The third was the character of a juvenile was not as well formed as that of an adult. Roper v. Simmons is what protects children under the age of 18 from cruel and unusual punishment prohibited by the 8th Amendment. One major finding in this decision was that juveniles do not have the same culpability as an adult when committing a crime. Steps in the juvenile justice process. Delinquent behavior is the first step in the juvenile justice process, which is where a juvenile's behavior is to a point where the juvenile justice system must get involved. Referral. A juvenile enters the juvenile justice system with an arrest or a referral. Intake or diversion. This step is where intake workers at juvenile court, the probation agency, or a prosecuting attorney needs to determine whether the case needs to be processed in juvenile court or if it should be dismissed. Transfer or waiver. This stage is where, in more serious cases, a juvenile can be tried as an adult in court. Detention. This step is where a juvenile can be detained until their adjudication hearing, or to permit the juvenile to remain at home during the pre-adjudication period. Detention is an option when the juvenile is considered a danger to the community or a flight risk. Adjudication. This is the phase where a juvenile can be deemed an adjudicated delinquent, roughly the equivalent of being found guilty in criminal court. This adjudication hearing has no jury trials and is decided by a judge. Disposition. After a juvenile is adjudicated delinquent, the next step is the dispositional hearing. This is like a sentencing hearing in adult court. This is where a probation officer will examine the case and work towards a recommended intervention plan for the child. During the hearing, the judge will review this plan and hear from all parties involved in the case. Juvenile corrections. Juvenile will be put under the supervision using probation officers. Probation. Under probation arrangements, youth will remain at home under the supervision of a probation officer and may be required to adhere to rules, mandatory treatment activities, community service, or pay restitution. Failure to comply with these rules will result in placement into a residential facility. These residential facilities are designed to allow close monitoring of the juvenile held there. And then aftercare. This is the final step of the juvenile justice process, and it is a stage where the young person is supervised and supported during the transition back to the community.